Okay, let's unpack this. Imagine you're finally buying that dream flat. It's a huge step, right?
Definitely a massive
And
investment.
maybe you've taken out a pretty hefty bank loan to swing it, and you're paying interest on that loan
Yep.
every single month.
Okay, yeah. Standard situation for many.
You're waiting, really eagerly for the builder to hand over the keys, but they're late.
Whoa.
And not just a little late, really late. Months tick by, maybe even like over a year.
Right.
Meanwhile, you're stuck, maybe paying rent somewhere else, and you're still making those loan interest payments for a home you can't even get into.
It feels incredibly unfair, doesn't it? You're literally paying for the developer's delay.
Exactly. It's maddening, and it leads to a really sharp legal question.
Which is the developer actually responsible for that personal bank loan interest you're paying just because they were late?
Precisely. And answering that specific, crucial question is what we're doing today. This is actually the latest in our Legal Snippet Law Simplified series.
Where we try to break down one specific legal point.
Yep. And today, we're zoning in on a recent, really relevant ruling from the Supreme Court of India that dealt with exactly this issue head-on.
We're going to do a deep dive into a specific Supreme Court judgment. It's 2025 INSC 808 to really get under the hood of the court's thinking.
And crucially, what this clarified rule actually means for you if you're a homebuyer stuck in this kind of delay.
Our goal is simple. Cut through the legal jargon, get to the heart of this decision.
Look at the case, the background, the specific problem the buyers faced, what the lower courts decided.
And then why the Supreme Court ultimately drew a line saying, hold on, when it came to making developers pay that personal loan interest.
So where does the story start? How did it even get to the Supreme Court?
Well, it begins with GMADA. That's the Greater Mohali Area Development Authority.
Okay.
Back in 2011, they launched this big housing scheme called Purab Premium Apartments. It was in Sector 88, Mohali.
Right. People apply, hope to get lucky.
Exactly. And two people who did get lucky, at least initially, were Anupam Garg and Rajiv Kumar. They applied, and they were allotted flats in a draw of lots. That was March 2012.
Okay, so they're in. What happens next?
Well, GMADA issues this really key document, the Letter of Intent, or LOI.
DLOI. Got it.
For Mr. Garg, this was dated May 21st, 2012. And this LOI, it laid out all the terms, price, payment schedule, and the really critical part, the promised timeline for getting the keys.
Ah, the delivery date. What did it say?
It had a pretty clear promise. It said possession of the apartment would be handed over within 36 months from the date of issuance of letter of intent.
36 months. 3 years.
Yep, provided the development work was done, of course. So counting from May 21st, 2012, that meant the promised date for possession was May 21st, 2015.
Okay, pretty clear deadline then. May 2015.
That was the promise. Now, here's the problem, and it's a common one, isn't it?
I bet I know where this is going.
May 2015 came and went. Development was not finished. The project just wasn't ready.
So no keys.
No keys. Possession wasn't actually offered until much, much later, June 2016.
June 2016, that's what, over a year past the promised date?
That's right, more than a year's delay. And that delay is what kicked off the whole legal battle.
Because the contract, the LOI, it must have said something about potential delays.
It did. Clause 3.2 specifically covered this scenario.
Okay, what was the deal if GMADA was late?
It said, basically, if GMADA couldn't deliver within the 36 months, the buyer had a choice. They could withdraw from the whole thing.
Just pull out?
Yes. And if they chose to withdraw, GMADA would have to refund the entire amount the buyer had already paid.
Okay, full refund. Plus
8% interest, compounded annually on that amount.
All right, so an exit option with, a reasonable interest rate back on their money sounds fair enough on the surface.
It seems like a defined remedy. But there was this one little phrase right after that.
Ah, yes. The fine print.
Kind of. The clause also stated, apart from this, there shall be no other liability of the authority.
Ooh, no other liability. That sounds restrictive.
Exactly. It looked like it was designed to cap GMADA's responsibility strictly to that refund plus 8% interest deal if they caused a delay.
But here's where real life gets messy, right? Because these buyers, they hadn't just paid a deposit, they'd paid a lot of money by this point.
A substantial amount. Anupam Garg had paid over 50 lakh rupees, Rajiv Kumar over 41 lakh.
Wow, and where did that money come from? Not necessarily just savings, I imagine.
Well, the case details show that a significant chunk of this came from bank loans. From banks like the State Bank of India.
Okay, and that's the crux of it, isn't it?
That's the core problem. They were doing their part, making payments to the developer, often using borrowed money with interest attached.
Right.
But GMADA wasn't holding up its end on the timeline. So the buyers are stuck. They're paying interest month after month on their personal bank loans.
For a flat that isn't ready because the developer messed up.
Exactly. It's a direct financial hit caused by GMADA's failure, but that no other liability clause seemed to say tough luck about those loan costs.
So they're feeling this pinch, the ongoing loan payments for a flat they can't use. What did they do?
Well, they took action. They filed complaints with the State Consumer Disputes Redressal Commission in Punjab.
The State Consumer Forum.
Okay. Their argument was pretty straightforward. GMADA's delay was a clear deficiency in service under consumer protection law.
And that this deficiency caused them real financial loss.
Yes, specifically including the interest they were bleeding out to the banks on those loans.
Makes sense. How did the state commission see it?
Well, the State Commission was largely on the buyer's side. They agreed, yes, GMADA was deficient in service because of the delay.
Okay, so what did they order?
They ordered GMADA to refund the full deposited amount and pay the 8% compounded interest on it, which matched the LOI terms.
Right, the standard stuff.
Plus, they awarded compensation for mental agony and harassment, 60,000 rupees each, and litigation costs, 30,000 each. Pretty standard remedies in these delay cases.
Okay, that covers the investment, the distress, the legal fees. But what about the big question? The bank loan interest.
Yes. They went further. Crucially, the State Commission also ordered GMADA to pay the interest that the complainants had actually paid to their banks on those specific loans taken for the flat.
Wow. So they did make the developer liable for the buyer's personal financing costs caused by the delay.
They did. It was a pretty significant addition, going beyond just refunding the investment with interest.
That's a huge step. I can imagine GMADA wasn't exactly thrilled with that part of the ruling.
No, they definitely weren't. They appealed this decision right away, taking it up to the National Consumer Disputes Redressal Commission, the NCDRC.
The National Level Consumer Court. What happened there? Did the NCDRC push back on the loan interest part?
Nope. The NCDRC reviewed the whole case, heard the arguments, and upheld the State Commission's order completely.
Including the bank loan interest payment.
Yes, including that specific direction for GMADA to cover the bank loan interest the homebuyers had paid because of the delay.
Okay, so now you have two consumer forums, state and national, saying, yes, developer, you delayed, you pay the buyer's loan interest. That seems pretty definitive.
You'd think so. But GMADA wasn't done. They decided to take this fight all the way to the top.
To the Supreme Court of India.
That's right. They felt aggrieved, especially about that one point, the bank loan interest, and filed an appeal.
Now, it's really important to understand the scope of the Supreme Court appeal, isn't it? They weren't trying to undo the whole thing.
Exactly right. Their appeal was incredibly focused, laser sharp. They were only challenging the part of the orders that made them pay the interest on the home buyer's personal bank loans.
Just that one specific element.
Correct. They were not fighting the requirement to refund the principal amount paid by the buyers. They weren't fighting the 8% interest on that deposited amount. They weren't even fighting the compensation for mental harassment or the litigation costs.
So they basically accepted liability for the delay and its direct consequences on the investment and distress.
Yes, they accepted all of that. Their entire fight in the Supreme Court boiled down to just one question. Should we, the developer, be forced to cover the interest on the buyer's personal bank loans?
Okay, so the highest court is looking at this very narrow but potentially very impactful question. What was GMADA's main line of reasoning? Why shouldn't they pay it?
Their core argument was that how a buyer finances their purchase is, well, their own business. Whether you use savings, cash, or a bank loan, that's a personal choice.
Right.
And the interest on that personal loan shouldn't become the developer's legal responsibility, especially when the contract didn't say anything about it. It's outside the scope of their relationship, they argued.
And the buyer's counter-argument must have been something like, hold on, your delay directly caused this specific financial damage, and consumer courts have the power to award fair compensation for actual losses suffered.
That's the essence of it, yes. They likely argued that consumer forums aren't strictly bound by contract terms when there's a deficiency in service. They have broad powers to ensure justice and compensate for the real harm caused by the developer's failure.
So you've got these two opposing views hitting the Supreme Court. How did the court approach this? How did they untangle who should bear the cost of that bank loan interest?
Well, the court started by acknowledging the established principles. They looked back at previous cases, precedents.
Like which ones?
Cases like Bangalore Development Authority and GDA v. Belbir Singh. These cases confirm that, yes, absolutely, Buyers are entitled to compensation if possession is delayed or the project is canceled.
So developer liability for delay isn't in question.
Not at all. That compensation usually involves getting your money back with reasonable interest and maybe some extra damages depending on the situation. That's settled law.
Okay, so compensation for delay equals standard practice. But then the court zeroed in on this specific issue of the bank loan interest. Why did they find that problematic, especially when awarded on top of other compensation? This is the core, isn't it?
It really is the heart of their analysis. And they laid out a few key reasons. First, they looked at a case the lower courts had relied on, Priyanka Nair.
Okay, what about it?
The Supreme Court said the lower courts had actually misunderstood or misapplied that precedent. In Priyanka Nair, compensation was given, and the court did mention the bank interest rate.
Ah, so it did come up.
It came up, but as a factor considered when deciding the overall compensation amount for harassment or loss. The crucial difference, the Supreme Court said, was that the Priyanka Nair case did not order the developer to directly pay the interest the buyer owed to their bank.
Okay, that's a subtle but really important distinction. Considering the loan as context for overall damages versus ordering direct payment of the loan interest itself.
Exactly. It's about how the compensation is structured. The second point was even more fundamental. The court stated very clearly that the source of the funds a buyer uses, well, it's irrelevant to the developer.
How so?
Whether you paid using your savings or borrowed from family or took out a bank loan, the court basically said that's not the developer's concern. How you finance the purchase is your personal arrangement.
So the developer's duty is just to deliver the flat or compensate for the delay in that delivery, not to worry about your personal loan agreement.
Precisely. And this ties directly into their third point. What is the compensation already awarded actually meant to cover?
Right, they were already getting 8% interest on the money they'd paid to GMADA.
Exactly. And the Supreme Court reasoned that that 8% interest on the deposited amount is the compensation for being denied the use of that money and the apartment itself during the delay.
So it covers the investment loss.
It's the compensation to the investment maker for the amount of money and the time he's been denied the fruits of that investment. That 8% is designed to make up for the consequences of the delay on your investment in the project.
Okay, that makes sense. The 8% covers the project-related loss.
Yes. And therefore, awarding both that 8% interest on the deposit and ordering payment of the interest on a personal bank loan would be like compensating the buyer twice, or under various heads, for the same basic problem, the delay.
Ah, the principle against double recovery for the same harm.
Exactly. The court cited another case, DLF Homes Penchula, and said compensating under multiple heads for the same default is not sustainable. You can't pile on different types of compensation for the exact same failure, especially when one type, the 8% on deposit, is seen as covering the core investment loss from the delay.
Right. Avoids double dipping, legally speaking. Anything else?
And finally, the court did bring it back to the contract. They noted the LOI did specify a remedy, 8% interest on refund in case of delay, and it explicitly said no other liability.
So the contract terms mattered.
They did. The court felt that this agreed-upon clause, offering 8% on the deposit, was a reasonable way to handle compensation for the delay's impact on the investment itself.
Okay, so putting all that reasoning together, the misreading of precedent, the irrelevance of funding source, the 8% already covering investment loss, avoiding double compensation, and the contract term, what was the final verdict from the Supreme Court on the bank loan interest?
Based on all that, the Supreme Court allowed GMADA's appeal, but only on that specific point.
Meaning?
Meaning they struck down the part of the State Commission and NCDRC orders that had required GMADA to pay the interest incurred by the homebuyers on their personal bank loans.
So bottom line, developer does not have to pay the buyer's bank loan interest caused by the delay, according to the Supreme Court in this.
That was the final ruling on that specific issue.
Okay, but let's be super clear. Just because they got off the hook for the bank loan interest, what happened to the rest of the order? Did GMADA still have to pay the other stuff?
Oh, absolutely. The Supreme Court was very explicit about that. The rest of the orders from the lower consumer forums remained completely intact.
So GMADA still had to.
They still had to refund the entire amount the buyers had deposited. They still had to pay the 8% compounded interest on that deposited amount, as the LOI promised. And they still had to pay the separate compensation awarded for mental agony, harassment, and litigation costs.
So everything except the bank loan interest stood.
Exactly. The only part that got reversed was the direction to cover the interest on the home buyer's personal bank loans.
Okay, that really clarifies the outcome. So let's boil this down. What's the key practical takeaway from this whole deep dive for you listening as a home buyer or just someone interested in consumer rights in property deals?
Well, the main lesson here, as clarified by this specific Supreme Court judgment, is this. Developers are definitely liable for compensating you if they delay handing over your property. That's clear.
Right, through things like interest on the money you paid them or other damages.
Yes. But, and this is the key point from this ruling, that liability generally does not stretch to covering the interest you are personally paying on a bank loan you took out to buy the place.
Even if you're only paying that interest because they were late delivering the flat?
That's the tough distinction the court made here. The compensation you get for the delay, like that 8% interest on your deposit in this case, is seen as making up for the loss of the use of your investment, the money you gave the developer.
Okay.
Your personal financing choices, like taking a loan and the interest rate on it, are viewed as kind of separate from the developer's main job related to the project delivery and the value of your investment in that project.
And you mentioned the contract terms earlier. They play a big part, too.
Absolutely. The specific clauses you agreed to in your initial agreement, like the one here about 8% interest on refund and no other liability, are really significant in defining exactly what the developer has to do if things go wrong with the timeline.
Got it. So this deep dive really highlights a specific, but yeah, incredibly important boundary line in developer liability. It shows the nuances in how courts calculate fair compensation under consumer law.
It really does. It shows how the legal system tries to separate different types of losses and assign responsibility when a big transaction like buying property hits a snag.
And maybe it leaves us with something to chew on, right? Because on one level, the court's logic makes legal sense. The developer didn't sign your loan papers. Your financing is your choice.
Right. Legally distinct agreements.
But on another level, man, it can feel deeply unfair for the homebuyer who's stuck paying thousands, maybe lakhs, in interest purely because the developer dropped the ball on the delivery date.
It raises that question of fairness versus strict legal liability.
Exactly. Does this ruling strike the right balance? Or does it feel like the buyer is left holding the bag for a cost directly triggered by the developer's failure? How much responsibility should a developer bear for the financial fallout their delays cause beyond just the investment loss itself?
Those are the big questions, aren't they? And they fuel a lot of the ongoing discussion about consumer protection in the real estate sector.
They certainly do. And that brings us to the end of this deep dive.